Welcome to the Central Pennsylvania Real Estate Investors Meetup podcast, keeping you up to date with what is happening in the York, Lancaster, and Harrisburg, Pennsylvania real estate markets.
Welcome to the Central Pennsylvania Real Estate Investors Meetup podcast. My name is Chad Eisenhart. Each week I go to local real estate meetups in York, Lancaster, and Harrisburg, Pennsylvania, and rebroadcast the meetup in their entirety. Whether you're a new real estate investor, just looking to get started, or own 100 doors, meetups are a great place to connect with like-minded individuals, including buying and selling your deals, and keeping up with what's new in your local market. I'm a buy and hold real estate investor focused on single-family, multifamily, and self-storage in York, PA, and can be found at chadbuys.com. This week, I'm at the Real Estate Investors of York November meeting, hosted by Dave Hyson and Harry Naill. This evening's speaker is attorney Kurt Blake, a prominent local real estate attorney and part owner of Anchor Abstracting. Kurt discusses how to handle your security deposits, why you need to itemize the cost of each tenant damage, and don't stop when you reach the total of the security deposit. Lead-based paint notices, upcoming changes to the Pennsylvania eviction process with respect to online filing, the max late fee you can charge your tenants, how to handle property your tenant left behind, how to handle additional forms of communication, including text, email, posting at the door, and phone calls, how to handle foreclosure properties you purchase that still have owners living in the house, and some nightmare scenarios that go with it, how to handle rent-to-own and lease with options you have with tenant buyers, setting up rooming houses, and getting proper zoning approval. And now on to this week's episode. Thank you.
Grab a seat if you didn't grab one so far. There's a lot more of them in the room tonight, so I'm sure you'll be able to find one. We're trying out this layout, so you'll have to let us know what you think. I know it's not not now. And I didn't.
Send us an email.
All right. To the complaint department. As soon as I'm like, oh, that Luckin Ball, I'm just going to pitch it. So we're trying this out. I know it's not as intimate as the tables, but there's a lot more of you guys showing up, so we had to do something. So, and it's probably going to continue this way, so we'll have to we'll probably end up putting in additional rows or something, but we just wanted to try it out tonight, see how it worked. But we wanted to make sure you guys had desks because I know you're going to be taking plenty of notes this evening. Everyone made it okay through the crippling traffic out there? I thought half the room wouldn't even be here.
It only took me an hour and a half to get from Hanover.
You guys are motivated. Harry's going to be talking about that a little bit later, about focusing on your goal, not the problem. So glad to see everybody made it. We're going to do a little bit intro. My name's Dave Hyson, one of the owners of Country Home Real Estate, one of the hosts of the group. My co-host, Harry Naill. Harry, do you want to give your...
Sure. I've been in real estate 34 years and also a national training coach with Fortune Builders.
Yeah. He's a real estate broker, too. You didn't mention that.
Yeah.
What doesn't he do?
Yeah. Yeah. An all-around snazzy dresser.
Flipper and landlord also.
So one of the things we'll talk about, I know a couple people hit me up before the meeting saying, how can I join? How can I become a member? If you're interested in becoming a member, see the gentleman in the back, Mr. Kling. He will tell you exactly what you need to become a member. He'll set you right up. We're getting toward the end of the year now, so we're running a promotion. I think we're doing it. We do it pretty much every year where you'll get the last month free with your membership, and you'll get to come the last month. Next month, we're not having a regular meeting. We're having our holiday party. So as a member, that's one of the events you get to attend. So if you haven't signed up yet, this might be a good time to do that. Not like right now, but sometime before you leave this evening.
Your membership also includes your spouse or your business partner as well, so it's a 2-for.
Yeah.
Networking is a really important aspect to any small business. It's absolutely critical. And when you come to a group like this, you're going to meet a lot of fellow investors. some beginners, some in the middle, some experienced who have a lot of properties. Also, you're going to meet contractors, attorneys, accountants. It's just a great place to come and learn to get better at your craft.
Right on cue. Didn't even see that. The other thing is we're obviously big on education. We want to make sure that you're investing a lot of time learning about your business. It's a lot cheaper to learn from somebody else's mistakes. And believe it, we've made quite a few of them, and we're not going to hold back on telling you about them. Probably Kurt will talk about some mistakes this evening too that other people have made, without naming names, I'm sure.
Yeah, I felt the janitor for Harry most days.
I'm keeping score, you know that.
Yeah. You don't spend 34 years in real estate without making a couple of mistakes, right?
Oh, a ton of them, and sometimes twice.
Yeah, I don't know if anybody else does that, but for me, I feel like I never learned the first time I make the mistake. So,
You gotta test it again.
Because it could have been a fluke, right? Usually, once it's twice, yeah, okay. Might want to change your strategy.
the other thing we have access to, which is the lease that Kurt was heavily involved in, is the state attorney general approved lease. We might be having some updates coming to that soon, but as a member, you have access to that. If you are a member and you don't have it already, send me an email, Facebook message me, and I'll send you the copy of the lease. And you also, as a member of this group, your membership also pays for membership in PROA. I still haven't taken that extra A off of there. I'll get to it one of these days. But it's Pennsylvania Real Estate Owners Association. And they're basically our lobbying organization in Harrisburg. So they look out for the interests of landlords.
How they came about was these big management companies who have these big complexes, thousands and thousands of units, they got tired of anti-landlord ordinances being passed by the townships, the boroughs, the cities. So they pulled their funds together and they hired an attorney to protect landlords' rights. And they've done a lot of great things that are in the lease. Kurt can talk about that later if he chooses to, but it's a good lease. And if you're not using a lease that's approved by the Attorney General of the state of Pennsylvania, you really should be.
Right. One of the important parts of that lease, and Kurt's going to talk about this a lot tonight, is the fact that it's plain language, which I think means a 5th grader or an 8th grader or something can read it, which passes the bar for some of the folks that we deal with. 4th grade.
Took it their friend's 4th grade class and they circled what they didn't understand back in the day. So.
Yeah. And then you got me with a master's degree typing this presentation trying to figure out how to spell attorney. Gotta tell myself.
ATTY period.
I like that. So the other thing is personal growth and motivation. You know, you guys, I assuming most of you are not full-time investors. I know some of you are, but a lot of you are probably at the stage of your career where you're still working a day job, and it can be less than motivating on some days when you go and you're around other people that can be somewhat negative. So it's important in this business, you're starting your own business, you're being in business for yourself, you need to be around other people that are entrepreneurial minded and positive and keeping you guys going, like keep the fire burning in your business. One of those things that you need to do daily. You get to hang out with Harry and I.
All right.
That's worth the price of admission right
I'm
there.
glad somebody's excited about it. Out of 50 people. Right? Obviously, we've been growing the organization. We want to continue to grow. So feel free to bring some people. I promise you we'll have seats for them. We'll figure it out.
Invite contractors if you know them. If they're looking for work and they're a decent contractor, invite them. They get a lot of business out of this group.
The other thing is if you're looking for private lenders and you are interviewing people that are considering lending you money on deals, bring them to the group, because while you're young or young in your investing career one way or another, you know, you don't have to have your credibility stand for itself. You can bring them to this group. They'll see the types of people you're affiliated with, and they'll see the types of information you're learning, and it'll help them feel more confident in taking a risk, because they'll know that you're not just going to completely waste their money, and they'll get a solid return on it.
And real quick, just in case you're not familiar with the difference between private lenders and hard money lenders. Hard money lenders are people who are in business of loaning money. They're savvy, they know what they're looking for. They're going to look at you, they're going to look at the asset, and they're going to make sure all the I's are dotted and the T's are crossed. And they're going to be obviously charging more of an interest rate than a private lender. A private lender is your uncle's, sister's, brother's cousin. You know, somebody who never loaned money for real estate. They really don't know much about it, but presented with the right opportunity, they might just loan you the money. And that interest rate's going to be a lot less. And they won't charge points either. Nothing wrong with paying points and nothing wrong with going with a hard money lender. I've done it tons of times. But obviously, if you can get the money cheaper. So invite them, like Dave said, they'll come here and they'll start to feel more comfortable about loaning you the money.
Or they might learn that your deal sucks and they're not going to loan you money on that one. But that is bad. That's good for everybody.
That's good.
Because you shouldn't do the deal anyway if it sucks. We want to thank a couple of our sponsors. One of them, Slate House Property
Chad,
Management.
raise your hand.
We got Chad here. We don't always get grace with his presence, but he's here this evening.
When I hear evictions, I'm like, where?
Right. Like, we're not actually going to evict anybody tonight.
Well, the night's still young. Frank's Granite and Marble. Carmen's not here tonight, but they do a great job. And they also have a flipping package for flips. Pretty reasonable. Where's Darren? Anchor Abstract. Darren runs that, and that's also part of Kurt Blake's law firm. They do a great job. They probably do more investment real estate than any other firm in York County. So they understand investments. They understand how to get the job done. So if you need a title company, give them a call.
That's important when you guys are choosing a company to close your deals with. You want to make sure that you're sending it to a place that's familiar with the type of deals we do and isn't just looking to close a vanilla box FHA transaction on a brand new home.
Especially if it's a wholesale deal.
Yeah.
Mark, there he is. Miracle Method, they've done several jobs for me, probably 4 now? 4 or 5, yeah. You get that ugly green or blue tub from the 70s, and you don't want to tear it out and have the mess in your house or the cost. They'll come in, it's a 7 patented process. They'll paint it, and it looks beautiful.
Sounds good.
See our sponsors after the meeting if you need more information. Get to know them, network.
I'm going to pass my mic over to Kurt, and I'll let Harry do the introduction.
Thanks, sir.
I shouldn't say Mike. 'Cause
You know, I forgot to call you today and get your bio.
That's all right.
I'm going to let you do your own intro. And then I'll make jokes.
In a public forum, I'm not friends with Harry. Let's get that straight. I was asked to set to you, so I showed for you guys, not for Harry. That's our introduction. Hey, can we turn this off so I can? Yeah. Okay.
So it doesn't blind you.
Yeah, that'd be nice. I was figuring it out before I came in today. I've been the solicitor, I think, with this group since 1995. And I've seen it from the West York fire halls all the way through all the different places that we've been in meetings. So it's sort of a neat transition to see where we are. A little bit of background. I've been an attorney in York since '93. I'm with Darren at Anchor. We do the settlements. I have my real estate broker's license. And most importantly for tonight is I teach the judges statewide on the landlord, tenant, and real estate issues that we are presented with. We start in the first and second week of September with teaching their lesson plan. And what I then do is I come to you guys in the fall once we sort of see what their hot topics are, and we take the crucial parts of that lesson plan, implement them to you guys, and give you the same updates you're hearing around the state for judges. There are some cases that have come out, so I put together a little handout for you. The handouts are really addressing a really crucial area, and that's the security deposit. Security deposits are an area of law that, just as background for everybody, when you guys are looking at new tenants, let's say, and you're looking at the rental, in year one, you can absolutely take 2 months security deposit. After year one, however, you can only hold 1 month security deposit, and you can step it up as your rent steps up for the first 5 years, but you cannot hold more than 1 month security deposit. So the case that we have at start off is a case called ES versus GAO, and ES is a property management company out in the Pittsburgh range, and GAO is a actual Chinese national group of students that were coming to Pittsburgh University. And the aunt's running around trying to find them housing, walks into this property management company and says, hey, we want to get them housing. And they said, we need this monster security deposit, first and last month's rent, double all this stuff, and you're not US citizens, and we have a really hot market. And they took over $5,000 in deposits. No paperwork was signed, no lease was ever entered into, and when they asked for their money back, the property management company said, no, we're not giving it back. The case went through a whole lot of trials, hearings, went up on appeal, and what the appellate court said, it's really important for you guys to understand this, is you're a business operation. And because you're a business operation, you owe your tenants, the consumer, fair, undeceptive, or not being deceptive business practices. If you do those things, you're good. If you get deceptive in your practice, you misrepresent things, you take things you're not entitled to, they're opening up the doors to the consumer protection law in Pennsylvania, and they're saying, hey, we can get triple or treble damages and attorney fees for the tenant. So just as some background, let's talk about security deposits. When you get them, best course of practice, put them in an escrow account right away. Put them in there. Put them into an interest-bearing account right away. Yes, it's a minimal interest, but most banks and financial institutions are going to put them in that you can have a sub-account within your main account for every single tenant, talking about what they have, what interest they've earned, things of that nature, and you can have an accurate, easy accounting for those tenants. Part two is when a tenant moves out, you lock them out, you find the place abandoned, they tell you notice that they're moving out. You have to give them that security deposit disposition letter. Just a simple letter. It doesn't have to be a real fancy form, but it has a really crucial part. And this is the second case that's on this materials. When you give your security deposit letter, a lot of people used to say you had a security deposit $800, I'm keeping it because X, Y, and Z. And they didn't break out the dollar amounts between the items. The case that came down is saying when you give a security deposit letter, so for easy math, let's say it's a $1,000 security deposit. If you have a whole bunch of items, list every single one, list the dollar amount next to each single account. So if they have a broken window, put broken window, $50. Torn up carpet, $100. If you just put broken window, torn up carpet, holes in walls, and put the dollars at the bottom and don't spread it out, the court's saying you're waiving that claim and you can never make that claim for that damage in further court proceedings. So really big change, a big one that we're seeing is you absolutely have to itemize it out and put it there. My kind of prudence for you, the best course of practice is get in the habit of just doing it every time as soon as they move out, whether they give you the forwarding address or not. That's the one thing in the statute, they're supposed to give you the forwarding address. The case law has been changing. They're letting if you knew where they worked, if you had their email address, if you had their phone, you could text them. Some of these courts are opening up that area. So just do it every time. If you don't think they gave you a forwarding address, send it to the last known address. Send it to your property they rented from you. Send it to their work address, mark personal. But take that step to have that in your files and really break it out. If you have a $1,000 security deposit, don't stop your letter at $1,000. Because if they challenge it and get one of them set aside as unreasonable, you might have an issue there. So list everything. If you have outstanding rents, late fees, if they have filing fees, if you've evicted them and had a judgment, put it all in there. Lay it all out. Make it comprehensive. Have it detailed, though. Make sure you have that information there because it's a big problem. If as landlords you don't do the security deposit disposition correctly, the tenant can sue you under the security deposit law for double the security deposit. So you want to make sure, just follow this protocol. Have it in your system. We locked them out. Put it in there 30 days from now. I better have that letter out the door. And you really need to make sure you have some proof that you got it out the door in that 30th day. I've had a couple cases where the tenant didn't get it to the 35th day. You put in the mail in York, they got postmarked in Harrisburg, it's now the 32nd day. We don't have any proof when you put it in the mail. So try and get ahead of the curve. Some people have emailed it themselves the day they send it, so they have proof of it. Some have taken pictures. Whatever way you can evidence and have that in your records, do that. The next part, when you have these security deposit cases, a lot of tenants are coming in and they're saying, hey, you know what? It was in that condition when I moved in, or I didn't cause that didn't exist, prove it existed. There's an area of law called spoliation of evidence. And spoliation of evidence says that if I'm going to claim damages, if I'm going to say that you broke something in my house, you ruined the walls, the carpets, I have to be able to prove that. Doesn't mean I have to keep the carpet in a storage room for the rest of my life until I go to court. Doesn't mean I have to keep the house in a condition unfixed, but I should document it. Take pictures, take videos, make sure you have some method of proving the existence of that condition is when you go forward with it. If you don't do that and you just come in and say they had a hole in the wall, it was $50, and the tenant has an attorney or the tenant's smart and says, hey, show me that $50 damage, show me that picture, show me the hole in the wall, and you don't have that, most judges are not going to give you that damage award. Now, because you haven't proved that damage, you're subject to $100 cost for that, plus they start opening up other windows on you. So just keep an idea that you're looking at that area of the law. All right? Anytime you guys have questions, jump in. Yes, sir.
On that letter, are you doing replacement costs, or how? What becomes overflow, like a window? Is it 150? At what point do you oversell?
So that's a really good question. What do you use? Nothing says you have to go and get a contractor to give you an estimate that you have to attach to it. And frankly, a 30-day window, some of that would be very hard to do. However, one of the things that a lot of landlords, management companies are starting to look at, there's some nationwide guides that are out there, and they lay out some of these nationwide pricings that they average by regions and such. Some of the builders have them as a resource. We've been looking into that as an option of almost having an addendum to your lease, like a 1 or 2 page addendum for the most common issues that we run into. A 10 by 10 room carpet, 10 by 10 room painting, that we could almost have the parties agree in advance in their lease that in the event this is a damage you incur, this is agreed upon as a reasonable dollar amount for that to be remedied. Something that way. That's one of the things we're starting to see a lot of them get into. One of the things to keep in mind with tenants and repairs and maintenance, you as a residential, if it's as long as it's a residential lease, have the absolute obligation to maintain the property. You can't pass that off to your tenants. One of the judges in a class this fall brought up a lease out in Pittsburgh that pretty much said the first $250 in any repair bill is a tenant's expense. Not allowed under Pennsylvania law. You're required under what's called the warranty of habitability to take care of maintenance. When it gets beyond normal wear and tear, where it's damaged, where it's excessive use that way by the tenants, then that's when you're allowed to step in and say this is the tenant expense. So when we're looking at these security deposits, it's not every single damage in the house, it's the beyond normal wear and tear. So one of the things you have to look at, if you've had a tenant there for 10 years complaining about paint condition on the wall, the carpet's a lot different evaluation than somebody that's been there 6 months. So just something to keep in mind. You're gonna have to look at, what's the length of time they've been there. I've had judges question when my clients charge the extra fee because there's a pet in the house. Now they want to complain about the pet marks or the stains or whatever. Well, what was that extra fee for? They're asking those kind of questions. So make sure that when you're looking at these things and saying this is damage, it's beyond normal wear and tear, you're going to have to be able to evaluate that and say length of time they were there, number of people in the house, things of that condition that you're looking at.
Kurt, while you're on the security deposits, there's, a lot of things get thrown around about the pet policy. Bring us up to speed, because I know they were thinking about changing that, our lawmakers. I don't know if they did or not.
As far as support animals, or?
No, I'm sorry. About having to give the pet security deposit back after 1 year.
All right. So one of the things in this ES versus GAO case where they found that the management company was deceptive was they actually took on more monies than they were entitled to take. And I've litigated this case in York County 12 times or more, and I've won every time. My client never got hammered with it. But now with this case out there, we've got problems. We've got to watch that you're not taking more. So if you're collecting monies in the beginning, it should really be first month's rent and double security deposit. A lot of people are doing the practice of first month's, last month's, and 2 months security deposit. Excuse me, and security deposit. That's really the 4 months. That's going to be too much, and they're going to see that from this case as a deceptive practice. You know, I pitched one of the questions out there. I've had some really poor credit risk applicants come in, and they're like, you know, hey, I know I don't fit your criteria. I know I'm not there. I'll pay my rent in advance for the year. You know, I pitched out at one of the meetings I had with a bunch of lawyers, is that something we can't consider now with a bad credit risk? Are we stuck with max of 2 months security deposit and first month's rent, or can we have a prepayment of rent amounts? That's something we're going to see develop where it goes, because clearly there's a problem with the way they're looking at this. There's a saying in law, bad facts make bad law. The ES case is a terrible case. The landlord in that case, in my opinion, did a horrible job in how they handled things, how they litigated it, how they preserved issues. But that's what we're stuck with as the law of the Commonwealth now from their actions, is that case. So as you go forward, just make sure, one of the best things you can do, first and foremost, we talked about the lease. Plain language Consumer Contract Act says you're supposed to have this lease that's easily read, it's easily understood. And when that act came out over 20 years ago, I had a friend that was a school teacher. We brought the original lease we had that was a legal size, front and back, tiny print, and I handed it off, and the kids couldn't read much beyond the first couple of lines. And it was that typical horrible legalese of party of the first part, herewith go forth with party of the second part, and endeavors to covenant to do, and no one knew what it meant. Landlords included, the attorneys included. So we broke it out into larger print size, how to explain things, how to give better detail. And as we did that, it expanded. So now the lease is like 17, 16 pages long in length, somewhere there. That's a matter of having expanded the font size, having explained terms out. When we brought it out, I brought that back to the 4th grade class, and they pretty much circled what they didn't know. We kept breaking it out, submitted it, and it was eventually approved by the Attorney General's office. There are changes coming. The personal property abandonment law is getting put in there. Some support animal issues are getting put in there. A number of other issues are coming down the pike. Yes, sir.
For the easy to understand and readability for the law, is there a language barrier, or what is a language barrier? Could be anything. Is there a standard for English, or what how do we?
That law didn't require any other language. It was allowed to be in English only. However, on a landlord, if you do have English barrier issues, the lead-based paint form that you must give has online, I think it's up to 15 or 16 different languages available for the lead-based paint notice. Mm-hmm. So if you go on the EPA, I think I gave you the website in here. I'm sorry it's so long, but I was trying to bring you right to the spot. The lead-based pamphlet and the lead-based disclosures, the lead-based pamphlets are something like 15 or 16 languages that you can get it in a specific language. I can't highlight enough how important the lead-based paint forms are. It's really a very easy form. If you have a house built before 1978, when you sign the lease, when you sign renewals of the lease, sign the lead-based paint. Give them the pamphlet. It's online. You can print it off so easily. Fill the thing out completely. Make sure you date it completely. Make sure you initial where it says lessor, which is you, the landlord, lessee is your tenant. Just make sure it's documented. Nothing in that law says you have to hire an expert to evaluate your property. Nothing in that law says you have to do inspections. All that law says is if you have notice, if you have reports, you give it. If you don't have those things, you check you have none. You give them the form. They have the right to, if they want to do an inspection or they can waive it, they do that. They initially got the pamphlet and you've complied. It's signed and it's dated and you're done. You're in complete compliance and you go down the road. Do it every time and keep it. I'm a hoarder of paper is the best way to put it. The basement of my buildings is stuffed with files. I don't like giving paper up. As landlords, you should be at least scanning and keeping things for a period of time of at least 4 years. EPA is saying 7 years in some of their things these days. So don't go throwing these EPA forms out. Keep them in check when you do it. The EPA lead forms also needed if you sell a property built before 78. Do not get rid of those forms. Keep them. It's so easy to have them, and complete them. It's all online. We gave you the link in there to go with. Talking about leases. For years, our standard was we did a 1-year lease and it automatically renewed either month to month or to 1 year for an additional year. I can tell you, I am a huge advocate and been pushing this for about the last 2 years of a month-to-month lease to begin with. Your tenants do not care if they have a 10-year, 1-year, 10-month, or 1-month lease. When they want to move, they move. All right? When I'm your attorney at a hearing with a judge and I'm trying to prove that there's drug dealing going on, that they've moved people in, that there's excessive utility use, that they're making noise waking up the other neighbors, whatever the thing may be that they're in violation of your lease terms, many times I have hurdles that are very difficult to prove to that judge that exists. If you have a month-to-month lease, if we can't get the neighbor that calls your house every night at midnight when there's noise waking their kids up that won't show at the hearings, or the police can't cooperate because there's an investigation, all I have to do is give a notice of 1 full month that we're not renewing the lease. So if you came into me today, I would give a notice to that tenant simply saying, at the end of December, your lease ends, be out December 31st. You have no longer a right after that date. January 1st comes around, they're still there. The next business day, we then go to the magistrate. We file our landlord-tenant complaint, and guess what? I have about 5 questions to ask you. State your name. Was there a lease? Did you terminate it? Are they still there? What's the rent they owe? Our case is done. There's no credibility determinations, no other witnesses needed, and it's easy. So a month-to-month lease from your aspect, if you're having difficult clients in the future, is so easy to remedy. The only thing you want to be cautious of in anything you do in landlord-tenant, whether it's month-to-month, whether it's lease, is that you're consistent. We have fair housing discrimination issues that whatever you do, how you lease, how you renew, when you handle problems, your eviction processes should be the standard all the way through. Whether it's financial criteria, whatever it is, you just want to do it as a blind to who you're dealing with, looking at the paperwork in front of you with no other factors. So find it, get it in place, and go. Yes, sir.
Kurt, the month-to-month lease is terrific and everything. How do we demonstrate proper notice to the tenant that they've been notified that that they've been given their 30 days and this is our last month? And as a follow-up, if we want to send them that notice, most leases obviously run first to the 30th. Mm-hmm. If we want to, let's say we send it to them on the 15th, you have 30 days. Do we have to coordinate it with the end of each month?
You want to time it with the term it's renewed. You can't terminate it in the middle of the lease. So if you have a lease that starts on the 1st, if you give your notice on the 15th, it's not the 15th of the next month that it ends. It's the end of the next renewed term, so the end of the next month.
Right.
Yep.
And then proper notice. How do you demonstrate that they were notified?
Yeah, couple ways. A lot of times, most of them, if it's a local landlord, we'll have them post the property, personal service. That's one of them.
You take a picture of the posting?
We do. We take pictures of the posting and show that. The other thing that I'm doing now, one of the changes to the lease that we've been working on is getting an agreement we can email or text all these documents and notice. In the leases, one of the biggest reasons, there's 2 reasons you want to have a lease agreement. Number 1 is self-serving to me. I get to get attorney fees. All right? So number 1 is that. All right? That's the number 1 rule in law, right? Is make sure we're covered. That's the joke in law school. So that's number 1, because without it in writing in a contract, you don't get it from your tenants. Number 2 is there's a thing called notice to quit. If a tenant's in default and you're fighting over possession, if they've moved out and you're only suing for dollar amounts, notice to quit's out the door. There's case law on that doesn't matter. But if they're there and you're having to give them notice of default, they have a right to cure, to fix it. 10 days for non-payment of rent. There's absolutely no reason you as a landlord in a business position to take an additional 10 days to give your tenants time to pay it. Rent's due on the 1st. After the 5th, your late fees kick in. Late fees that are permissible, 10%. Per day fees are not permissible. Judges will not award them. I have harassed these judges for 10 plus years in class that the only reason that we now have case law and positions that it's 10% is it's the only math on the bench they can do. Some laugh, some agree, some just sort of ignore me and let it go right over their head. I think they're reading the newspaper some days, but 10% is typically the norm. I've tried to do sliding scales with time that it can step up higher. I've been shot down repeatedly on that. So 10% is that flat fee that works. So I like it, rent's due on the 1st, late after the 5th. I file by the 12th or 13th or the next business day. It's a 1 week after the late fee time period, in we go. I know that there is a theory with a lot of landlords and property managers, they wait till like the 22nd or the 23rd, so that when they file it, the judge is giving them that 1st, that 2nd of the next month, they can amend it and ask for their next month's rent. However, I'm a fan. They're not paying most times. I could go from that wall to the other wall and back with judgments of magistrates that have never been paid. So I'm a fan of not giving anything more. As far as time, as far as moving things along, Chad may tell you some point, but I had the chance to look at a great program they're putting together. Chad is in a group that has developed this amazing software that the state's going to be approving, that we're going to be able to online file our landlord-tenant cases. File them online, get them into the court, not have to mail it or hope they gave me the right fees. I'll share a story. 2 weeks ago, I call a judge up and say, what do we owe you for this case? 2 defendants, $1,200 in rent. They tell me $138.45 or whatever. We mail it down, goes to the judge, and we called down about a week later and said, hey, it's not on the system, where is it? They said, you gave us the wrong fee, we sent it back. Well, how much was it? It was $138.54, sir. Wait a minute, for 9 cents, you're gonna mail it back, cost me another week and a half, and you told me $138.45. Yes, we know, she made a mistake again. That cost my client 2 or 3 weeks of time on rent. We talk about $30 or $35 a day costing us. So for a fee, a very nominal fee to file it, we can get that file with the judge that day, get it in a system. We can do the possession orders when it goes live, that we're gonna be able to do the possession orders. You're gonna start kicking out 1, 2, 3 weeks per eviction savings here. So something to wait and see online, but I'm really excited about it because it's gonna help significantly. Yes, sir.
My question that I got is, so if you evict them and they leave property there.
Correct.
Whatever it is, a resident, do you have to legally dispose of it, or can you sell it to make yourself whole on what's?
Okay, good question. So here's a question. If I evict somebody as a tenant, then there's a couple scenarios I'm going to address under this. Let's say I go through the full possession. I've gotten my judgment initially. No appeal was taken. I now file my order for possession. We're going to get a lockout date. The constable's going to go out there and lock that door. In that order for possession is a notice to the tenant saying, when you're locked out, you have 10 days to notify the landlord if you want any of your property in the property, any personal property, TVs, clothes, appliances, whatever they left there. If they notify in that 10 days, they have a full 30 days from lockout date to get their things out, and you can't do anything with it. You could, as far as sell it. You can move it, you can store it, you can consolidate it, use reasonable care, video it so they can't claim there were 5 TVs in there you stole, that type of thing. But if after 10 days you get no notice, then you're free to dispose of it as you want. We had that provision in the lease, and they took a lot of the language in the statute from that lease provision. After the 10 days, you're free to do it, but if you make any money selling it, you have to give credit against any judgment that you have with them. Now, if you bring a landlord-tenant lawsuit, you're getting a money judgment and a possession judgment. So if you were to come into your property and you come in and there's valuable items, whatever they might be, you could always do a sheriff sale too, as a way to get title to these things. You could do a sheriff sale of personal property, get title to whatever's there to collect on your money judgment that way also. If you come to the property and you find the place empty, you give the tenant your notice to quit and they move out or whatever and you find it empty, you then have to give them a notice telling them they have 10 days, and there's rules about how we have to serve them and notify them. That's why what we're trying to do is build it into the lease in advance now, that they're notified. I don't have to track them down. When we find it empty, we start our 10-day clock and we go from there. So, Brandon? A 10-day from the tenant or to the tenant?
From the tenant, stating that they're coming on, they text them on the 9th day and say we're coming on that day to get our stuff. Is that?
I think it's.
Or does it have to be a letter from the tenant?
No, I don't think it has to be a written one delivered to you in letter form. I think if they notified you, yeah. There's
he's saying the text message is either.
Yeah.
The text message is permissible, I guess, either way, right?
Yeah. Well, that's where the second security deposit case, this Natardi versus Chabot case, that's where this landlord got into trouble because he got real informal with his tenants. Tenant says, hey, I want to move out early, I don't know. And the landlord pretty much said, yeah, that's okay. They had a written lease agreement that says you can only modify the lease in written format. But what happened was the court said, no, we don't agree with that. If your actions permit the change, the person relies upon it, you can do it. So in the Natardi case, the guy pretty much had an agreement with the landlord informally, he could move out. When they moved out early, landlord said, I'm not giving you a security deposit, you broke the lease and moved out early. So they looked at text messages, communications, emails as a format for it. So if you hear from a tenant that says, hey, Brandon, I want my stuff in there, I'll be back in the next 10 days, I consider that good notice. I wouldn't want to defend that case for you.
Even if it's from a friend's phone?
Well,
That's the gray area.
yeah, that's a big gray area.
Say you send your text message, but, they might have sent it to Kelly, but she may not have seen it, she may not have replied to it. How do I know that it's a formal message,
Well,
that it even came from that individual?
The one option you have is if you spell it on your lease that absolutely no text communications will be considered an appropriate message or communication method. It all has to be done as follow. That at least builds it for you. But I can tell you with the way technology is going today and the ability to show emails, you better keep up with technology.
I would take an email, but the text messages is so where you could miss it easily because you get 30, 40 texts a day like you do. You could miss one.
Oh, absolutely.
So that's I'm just trying to get the clarification as to what really we can accept because we do a big volume and that's a gray area for us because we have a lot of trash.
I would say if that's your concern, don't give your cell phone number to them, seriously. Because if they're going to start developing it, they have it. And the problem becomes is like I had a case where tenant dropped the keys off and it's a management company, had over 1,000 properties and they had made a copy of the key so it didn't have any of the numbers on it registering the copy. They throw it through a mail slot and said, I returned my keys on this date. Landlord's like, yeah, we got a key on a date, but we didn't know who it was. And the judge started me down the path of, well, you didn't return a security deposit timely. I'm like, one, we don't have an address, so I ended up winning it on that case, but he was willing to look at that their keys were turned in that day, so we were bound by that date, but we didn't even know who the key was. So there is a thing out there. So let's say you have a 1-year lease agreement. You can do what's called an acceptance and surrender. So I've had a scenario where I'm renting to a tenant, they come to me, hey, Kurt, I lost my job. I'm not going to be able to pay you next month. I agree just to get out, make it easy on you. You've been fair to me, thanks, kind of thing. We can make a handshake agreement, and it's called acceptance and surrender, and that lease ends at that point. They give up their rights. I give up my rights to further collections, and we're over with. And there's a value to that. If they're going to just string me along and hang me out there, I'd rather just take the key, cut my loss, and move on to the next tenant. So you can take that acceptance and surrender. You want to try to, if you can, document it. A simple letter, email, text, if that's your method, whatever you do a simple presentation just saying, hey, we had a lease for a year, you've agreed to turn the keys over today and lease is over. I'm keeping a security deposit, you're forfeiting it, whatever it is. As part of that, you can do that all day long. So.
We make an addendum to our lease that spells it out that we will not take a text message as form of communication and have them sign it and re-sign it so that they understand that fully.
I think that's probably a good starting point for you if that's really a concern for you. Get it out there because I've had a lot of judges get upset where people have said, I have text messaging, here's my proof. And
that's the frustrating part is we can make it real simple not to respond to a text message. If we have that proof that if I know I have a piece of paper, the tenant signed himself and acknowledge the lease signing, and we're given a copy of it.
It's at least a starting point for you, but I can tell you you're going to have to pay attention and make sure you're not, if somebody sends you a text message says, hey, Brandon, I still want my stuff, and you go in there to, and find stuff in there that's valuable on the 11th day, you're going to want to scratch your head and reconsider. And you're probably, if you call me, I'm going to say, let's at least do a sheriff's sale of personal property. Get them out there, and you do it through the constable, really. Get them out there, get a lien on the stuff, and we take it that way if there's valuable stuff, if there's any level of concern. A couple weeks. Yeah, you're more like 6 to 8 weeks, but it's.
So you got to transport and store it.
Well, they can come to the property, do it. You can consolidate it. When you come in and you find a house with this stuff, there are some landlords that are getting the portable storage. They've bought U-Hauls. I have one landlord we're evaluating a scenario where he's saying, I own a U-Haul scenario truck. I'm going to be cleaning this thing out one way or the other. I'll clean it out and bring it to you. Where do you want it? He literally is calling someone up and say, it's loaded, tell me where to bring it, just to get it out the door. And of course, he stacks the most valuable in the back of the U-Haul to make sure everything else gets unloaded first. But, simple tricks like that you have to sometimes think about.
Kurt, on a lockout,
yes.
If they call you 4 days and they want their stuff, are you allowed to say, well, that's great, I have no problem giving you your stuff, but you owe me $1,200?
Can't hold it hostage over the old rent.
Ruh-roh.
Yeah. Hey, can we
That was a couple years
rewind?
ago.
Can we please rewind that video about 30 seconds and start over again? Mike, sorry.
Just get back to that 30 days, you got your possession and they've got their 10 days to notify you. And let's say they notify you timely that, I want coming to get my stuff. When does the 30 days begin? Was it from the date of possession or is it from the date they notify?
Date of possession.
The date of possession.
Yeah.
So really you might be down, if they call you, if they text you or whatever on the 9th day, they got
21 days, yeah.
from
Yep.
the possession date.
Yes. Yes, ma'am.
I just had a question about the whole 30-day thing again also. If you're in a 12-month lease, which I'm doing this again, and I didn't change it, and you can't give somebody a 30-day if they're in the midst of a 12-month lease?
So if you sign a 1-year lease with somebody, you've committed contractually to them for a year. So you can't.
If they violate the lease?
If they violate it, the only way you're getting them out is you can give them a notice and say, hey, you violated, you've got 30 days to move out. If they don't move out, the only way you're getting them out there is you'll have to go to the magistrate to do it.
I did, and she didn't put them out.
Yep. So then you're stuck with them.
Okay.
Yep.
Not really. She'll be out, right?
Yeah.
There you
Yeah.
go.
Hey,
Atta girl.
on that thought again, that was not Harry Naill, but
Well, this time I gave her a 10 days.
yeah.
Okay.
So the one thing to keep in mind is when you're a landlord, you can only take possession one of two ways: by agreement with your tenant, or by court order. If you use self-help, you're going to get in trouble. So just watch those.
I guess I was under the misimpression that the 30-day wasn't about rent, so I didn't put rent on it.
Right.
She owed me, but there were a lot of other things that she did. Okay, and those were the things that were listed on the
Right.
complaint. When it got to court, the judge said, "Do you want her in there?" He said, "No." She said, "We're going to give her 10 days to pay you in there." Okay, so she did that time.
Now,
This time she won't.
when you go to the magistrate, there's two types of possessions. There's what's called unconditional possession and conditional possession. If you're filing the first half of that landlord-tenant complaint and it's only about dollars, you are conditional possession every single time, and that means it's pay and stay. So if they pay you, they stay. It does not matter. They're going to be allowed to stay. When that constable comes to lock them out, if they have the cash to hand the constable, they're staying in your property. So be really careful that just because you have an eviction order does not mean you're getting the property. Do not sign a new lease. I get that a lot. Do not sign a new lease till they're absolutely out of property, and you know that, because that pay and stay, being allowed to stay, is the one. If it's violations, if the lease is over, if they brought dogs in, if they're doing things like that, it's an unconditional one. That's also, if it's a month to month and I say we're not renewing it, it's an unconditional possession. It's still the same rights of appeal. If they appeal it, they can stay in while they pay rent each month, but it's at least expediting it for us.
Concur. Is it either or? Is there any way to get a judgment and unconditional? Or no?
Yeah, you can get a money judgment and unconditional possession if there's other issues.
Okay.
And I have language in the lease that says if somebody didn't pay November's rent, they have a dog there and they're causing damage, and I can prove that to the judge, I can get it. Yeah, I'll get the judgment for the November rent, and I'll get an unconditional because of the violation.
But like if they're on a month to month, and you give them a 30-day notice, say we're ending the term of your lease, can you still get a monetary judgment?
Yes.
On top of that.
Yep.
Okay.
Yeah, if they stay in, you can still sue for the rent amount. So yes, sir.
That's what I was gonna ask, so like this scenario that you said, if it's in the middle of the month, and they're still there, and then you go through the magistrate, that process, and that carries, you just say like right now, that carries you into December, and they're still not occupying it, but they still have their items stored there or whatever, then you can still collect your rent for December.
Correct.
As well as any other fees, like my tenant is responsible for the electric to the separate charge. So even there's set base electric bill that I can add that, or that, does that
Yep.
have to be an addition?
So when you file your landlord-tenant complaint, though, there's a box on the left corner, 2/3 of the way down, about halfway. You check it for rent due and owing at the time of the hearing. You can bring all that up. Now, here's something that we're considering too. If I bring a tenant to a landlord-tenant hearing in a magistrate and they appeal it, when they appeal it, they have to post money to stay in, and every 30 days they keep paying money in. The one problem, the one flaw in that is it's the base rent the judge finds due and owing at the hearing. All your add-ons for electric, sewer, refuse, water, all those other things do not get paid in. The tenant skates on those, ends up with a money judgment in the end. So one of the things a lot of landlords are starting to look at is saying, you know what, instead of $800 rent and you reimburse me for electric, water, sewer, and refuse, it's $950 rent with $150 credit towards your utility bills. Now when I bring my hearing in front of the magistrate, it's a $950 monthly rent. Now we're on appeal. I'm getting almost the full amount of the cost of them there.
But also into that though, what if you have to take the initiative to move the items out, like you said, and store them somewhere? Like for me, I have a storage facility as well. So now let's just say I tie up one of my storage units, housing their items, so it's locked, safe, key, everything. Can I still then charge them the fee for that month?
I think, as I recall in the law, I think there's a prohibition on charging them storage for that time period. But I can check on that and get your information.
During the 30 days.
During the 30 days.
After the 30, I suppose.
Yeah, but after the 30, they waive their claim to it. It's yours. Yeah, you know, we actually had a debate one day about the idea of taking the stuff under a lease agreement and automatically putting it in a storage unit. And the problem is at the end of 30 days, they waive all claims to it. But if I stick it in a storage unit claiming it's their unit, I have to now go through the storage facilities, you know, Self-Storage Facilities Act, you know, removal of it. So, Mike?
Going back to that 30 days with the, you know, the possessions and so forth, I think anybody who has any experience with tenants and the possessions and the ones that are smart enough to actually notify you, and then they will, you know, start the process of, you know, for, you know, I don't want to use any profane or anything here, but jerking you around.
Okay.
As far as, yes, you know, I've got the station wagon on Sunday at 7 p.m. Oh, couldn't make it, but I got it at Monday at 10. I mean, how much accommodation and how do you demonstrate the absurdity of some of the games that are played?
I have a case right now where it's a 4,000 square foot house that we got possession of, and it's filled from floor to ceiling in every room. The person has been there every day for 20 plus days cleaning stuff out. My client goes there 8 o'clock every morning, unlocks it. They go in 5, 6 o'clock at night. It goes back over and locks it every night.
That's a genuine accommodation for a genuinely unique
that is.
situation.
Yeah.
We're all talking about junk here and professional tenants.
But the problem is your tenant has that 30-day time period to get it. So some of them are playing that game. And, you know, I have it where they're like, I'll be there Monday. Oh, whoops, Monday didn't work. I'll be there Tuesday. Whoops, nope, Wednesday will work. You know, I've also had a situation where they've gotten in there and they've locked themselves in, and we go to get them out and we call the police, and the police says, looks like you had to file a landlord-tenant eviction. No, we don't. We already did. You know, they're trespassing under the court order, so then we have to go through the whole thing and deal with it. But York City twice tried to arrest my landlords for trying to throw the people out where they were not permitted and had been locked out.
Wow.
Yeah. I went running down. I had to fold. I'm like, no, hold on. I don't believe it's a once and done, because some of the scenarios they can't get it done in that time period. You cannot. There's limitations on charging them. It's a lousy area of law, which is why you can see some of these people are saying, you know what, I don't want my house held hostage for 30 days. I'm getting one of those portable places I own. I'm putting it in my driveway. I'm throwing the stuff in there, and here's a lock. You guys get the combination of it. Come and get it in the next 20 days. Yeah. Well, no, you got to be careful. Because then if other people steal it, they're going to sue you for that. Yep. Hey, a couple other quick things. If you're an investor buying properties at sheriff sales and such, there's a Tenant at Foreclosures Act out there. What that says is if the person in that house, let's say you buy a lot of these auction.com and places, you're getting it with the people in there. If they are not the owners, you have to give a 90-day notice. They get a 90-day Federal Act provided notice. They still owe you payment of rent, though, during that time period. They don't get a free 90 days. That's the one.
Closing on next week like that.
Yep.
The tenants are still living in there and they want to flip it, but they have to give them 90 days.
Yeah, they're going to have to give them 90 days because they're tenants. Now, the law says it has to be bona fide tenants. That means it's not the owners of the property, their families, or people for less than reasonable rent. Because a lot of times you have that $100 a month lease, they throw their friends in there and you're stuck with. But you do have that. I gave you the Asseline case. Asseline versus Reynolds came down March of last year. I did practically, if you want to believe it, I think I nearly accomplished a backflip when that case came down because it was such a great law for us. Unfortunately, this morning at 10 o'clock, our Pennsylvania Supreme Court overruled that case, and it's now done. So it's in your material, cross it out, it's no longer valid law. The law, just as way of background, was if you bought a house at sheriff's sale, tax sale, auction, whatever, and the owners were the ones still there, not a tenant, we used to have to go to the county courthouse, file ejectment lawsuits, take 6-8 months, spend a lot of money. The court allowed us to go through the magisterial court like a landlord-tenant eviction, give a 10-day notice and run with it. That process is now done. We can't do that process anymore. It's back to the county ejectment case. So if you're an investor and those things are pending, we believe if you've already gotten the magistrate's court order for possession and judgment and it's not pending, you can still proceed. If you're waiting for the hearing, they're getting all kicked out. So that just came down this morning and we're working through that. Oh yeah, a lot of them they're getting them subject to. And this was a pretty efficient way. And the cool thing was, doing it under this, if the people appealed, they had to post rent. So now they couldn't string it out. The Assaline case, the Reynolds lived there 14 years in an extended sheriff's sale. Never paid $1. Strung this bank out 14 years. Assaline buys it at a sheriff's sale, starts the process. The people end up living there 3.5 years, never paying anything. In the middle of this litigation, part of why it ended up being a crazy case was the house actually burned in the middle of litigation. Assaline and Reynolds both said screw it, walked away from the case, and all these different people fought the case for them. So the legal services fought for the tenant. There were some landlord attorneys fighting for the landlord side and kept it going. Ended up at Pennsylvania Supreme Court. Decision came down today, unfortunately, against the landlord side. But
So
yes.
I'm sorry.
Yeah. Go ahead.
Okay, I was just going to say, so if you do buy it like in an auction or a sheriff's sale and people are living there, you give them the 90 days. It's going to take 6 months?
Well, and there's a couple things. Number one, you have to have the deed. Mm-hmm. So if you're just a pending bidder waiting on settlement or waiting on the deed from a tax sale, you really don't have the rights till the deed's recorded.
Okay, so you get the
Deed's recorded, you get the actual tenant notice that they have 90 days before that lease is going to end, and they still owe you obligations of rent each month.
And the 90 day comes and they're still there.
Yep, then you file your eviction at the magistrate and you can get it.
Oh, right.
But if they're not a tenant, if it's the prior owner, and some of these are hard to figure out. I mean, we have it where we don't know who it is, and I cover the bases both ways. We send out a 10-day notice of default like they're the owner and a 90-day like they're a tenant, and said you either reach out to us and tell us, or we think you're the owner, we'll proceed as you're the owner. And then we go to
it takes how long then?
the owner's a magistrate. It's 10 days later we file, not 90.
Wow, okay. Nice.
If we're wrong, what we lose is the filing fee.
How difficult is it to get them out, either owner or tenant?
It'll happen. It's just some of them take longer than others. I mean, I have one guy that this week we were down in Stewartstown. He kept his mortgage at bay for 10 years. My client bought it. We had the hearing and he filed bankruptcy Monday. So, and now this case came down today that I should have had him out on Monday under, and now I have to start the process new at the county courthouse when we get the bankruptcy set aside. So he'll be another year that he'll just hang in there and live. So.
Well, we have one in York where she's lived there for 5 years.
Oh yeah, it exists.
But Kurt, I do have a question.
Sure.
Bona fide tenant, you give them the 90 days notice, required by federal
Yep.
law. The first month goes by, they don't pay the rent, can you then go ahead and evict?
You can.
Local custom?
Yes, you can.
like we normally would?
Yep.
Okay.
Yeah, you would have to give a 10-day notice to quit because of the failure to pay rent. Yep.
If you were to get that person to enter into a lease agreement with you for $10 or $20, could you then do it as a regular landlord-tenant?
You could potentially. Yep. Yeah. So let's say you go to a tax sale, sheriff sale, whatever. A lot of investors will go and meet these people, strike a deal with them, whether it's cash for keys to get them out, whether it's hey, I know I'm not getting a deed for 6 months or however long it's taking these days. On some, a lot of them will set up and say, I'm going to give you a 6-month lease for $1. You're going to sign a quick claim deed, so we have no arguments about title to property or objections. And then at the end of 6 months, if you're still there, you owe me rent at $750 a month. You could sign that kind of setup and then have it structured. If you're buying it, let's say I'm selling a 4-unit and you buy the 4-unit from me, you're then taking it subject to leases that exist. You couldn't do it that way. You'd be stuck with whatever leases I sign with those tenants. When you're buying with these tax sales and such, the argument is those leases are shredded, they're lost, and all they do is they get the 90-day protection. So,
How about squatters? How about,
But if they just signed a lease like 3 months ago, their lease is still good for 9 months if they have a copy of that lease, right?
If I buy it at sheriff's sale, all they get is 90-day window into that act. Yep, and I can get them out at the end of 90 days. Yep. Yes. This is the hot corner over here. How are you guys doing over here? You guys all good over here? Everybody good? So, hey, Mike, can we separate you two? At least make my neck kind of stretch both ways tonight.
This goes all the way back to the security deposit thing, and we've kind of gotten far afield from the lease, and that's all fine and dandy. But I do have a question about security deposits. When you're selling a building, and let's say you've had a tenant in there for a couple of 3 years, and they have a security deposit in place, and they have partially dissipated that security deposit through, easily demonstratable things like late payments and so forth. When you go to transfer the property, is it permissible to transfer to the new owner the detailed security deposit account statement that you described, at the beginning of your presentation? Each line, you were late in May, that's $35. You were late in June. So now you're transferring to the new owner a statement of facts that the security deposit is no longer $600. They've used up $300 for late payments. So I'm giving you this statement of fact plus a check for the $300 to the new owner.
If it's been handled that way through the course of it, I'm okay with that. But what I see is a lot of landlords come in, they've never told the tenant there was a late fee assessed, they keep taking rent payments, they keep doing it, and all of a sudden it's time to hand over the security deposit, which should be escrowed, but they've kept it in their own coffers and now they don't want to come up with it. And now all of a sudden there's 5 late payments and they're deducting that, transferring over it. That way I don't like. If you've given a tenant a notice saying, hey, you're late, I understand you're tight, we're going to take the $50 off your security deposit, here it is, and there's documentation showing regular course of business happening, I'm okay with it then.
So if you send an email to the tenant each time they have incurred a late charge, then you kind of covered yourself under
I think then you're at least showing it's been done, but typically most people expect the security deposits in place for the end of the lease.
Oh, I understand the expectation.
Yeah, so I mean it's, I've been on both sides of this argument too, and it's, my preference, truth be told, is I think it in total should be coming over. If there was a problem with tenant's payments, you deal with the tenant while they're there.
Between you and the tenant.
Yeah.
Yeah, I don't consider the security deposit live until the lease ends.
And the other thing is if you're doing something like that, I think if you're listing it on MLS or something, you should be saying, make sure your security deposit is listed properly on some of those addendums and such. Because I get a bunch of them that say, hey, rent's $650, here's the lease shows $750. We go to settlement, oh, there's no security deposit, sorry. And every single lease shows there's one, and now we're running around trying to get it. So I think if you're going to do it, you should be documenting it up front, make sure everybody's on board. There is a thing as a buyer of properties called an estoppel certificate. It really plays into commercial real estate more than residential, where you go around, you get a tenant to sign. They say, yes, my rent's $1,000, and yes, my security deposit's $1,000, and there's no defaults I know of the landlord. I'm not aware of any defaults of mine. They sign off on it. As you start seeing these security deposits bouncing around, I might be pushing more use of estoppel certificates in residential.
Which I guess makes sense in the commercial realm where, rents can be $1,000.
Lot higher, so.
Because you would have an escrow account, so you have to show that $30 coming out of your escrow account
You should.
every month. I mean, that would be the
Yep.
way to show it too.
Yep.
What's the most you're allowed to raise rents per year? Because I'm hearing tenants saying people are raising.
You know what? There is. We had that the question is what amount can you raise rents each year? Whatever you want.
Because California passed the law that put a cap on that.
Yeah, California did, New York did.
Maybe direction too.
There was an article online about it.
Waterford jumped. People were telling me they went from like $850 to like $1050 in 1 year. So there is no caps right now.
Yeah, there's no caps. Now, in a manufactured home park, you can only raise rents once a year, every 12 months. In a residential month to month, you could, if you wanted to, in a house, raise it every single month if you wanted to without restriction. You might lose tenants, but you're permitted by law. There's no rent caps. Yes, sir.
I understand that
I'll get you next.
Pittsburgh, the judges are only going to take people no matter what. I don't know if you've heard that. They say that they're contributing to the homeless problem by.
I think they're by law they're bound to.
So I was wondering what comments were with also with judges that are very liberal. What your comment was with Greg Rothman's HB 171.
I don't know which one that is.
House Bill 171.
What's it about?
It's accelerated discussion.
Oh, I saw some of that, but
That's the one Gary was lobbying for, right?
Mhm.
You know, pro lobbying that. And I hope everybody that got that from Gary actually went to the trouble like I did of contacting their state representatives about accelerating our possession rights by 10 days. Incredibly important to everybody that is a landlord.
well, that's where some of these other things with other states came out of too, because there was all these discussions about what other states were, the length of time, and how long it took. And some of them, like New York City, are brutal, amounts of time. I think the acceleration makes a lot of sense. If someone doesn't make their payments or not compliant, there's no reason not to push it forward. There's two ways, if you disagree with a magisterial district judge, there's two options you have. One is a straight out appeal. The straight out appeal is actually where you have to have a decision on the case all brand new. Or there's what's called a writ of certiorari. And a writ of certiorari is where you actually challenge that the judge was so out of line and so askew that he's violated the law. And that gets a different type of hearing with the judges. If around here we started having a judge that regularly was having problems, I know that President Judge Adams has met with other attorneys on these issues, talked to them, gone and met with these judges and say, hey, the law is very clear, here you are. And if I were to find out who some of these judges were when I teach them, I'd probably give them a little better earful about the case law. So,
Fortunately, around here we don't have it's rare, some of these stories that you're hearing. It's not like it's every day.
yeah, we actually have a very good bench around here on the whole. I mean, there's some that have their issues, but on the whole, they're very fair and consistent.
I've got around 100 tenants, and I don't really have any problems.
Can we do a lease without a security deposit, but instead charge on a separate contract an option consideration?
Oh, good question. So the question is can you do a lease, no security deposit, and have an option agreement? Be really careful with option agreements. So you have the right to go in front of the magisterial courts on landlord-tenant so long as there's no equity position for your tenants. If your tenants are buying the property, you lose the right to landlord-tenant, the magistrate. If there's an option, the judges, what we've been teaching them is they have to look to see, was that option exercised in any way? Did they take any steps to exercise it? If they haven't, most times they're letting me do the eviction, but even at that hearing, if the judge says to the tenant, you have this option for $500, you can buy it, what's your intention? Oh, I want to buy it. Sorry, case over, counsel. And I'm kicked out. They bring it to the courts and do an ejectment. So it is something to be very careful with your options because that's a problem. The other problem practically with options, if I'm renting it from you and for $500 I have the right to buy it for $50,000 in a year from now, what happens is your tenants become super focused on sometimes the condition of the property. So they start calling you about the windows are leaking and the furnace doesn't work and try to get you to put more money into it to fix it up for when they buy it in the end. So you want to be real clear about what you're doing condition-wise too. Yes, sir.
Position on giving purchase credit for monthly rent and that. Does it blur the lines between tenant and actual equitable interest if you're withholding money for them, or how does that work?
So the question is giving some type of purchase credit per month. I've seen a lot of options agreements. We'll give you a credit of X dollars per month towards a purchase if you do it. It doesn't blur. It blurs the lines in so much as if they've exercised that option or there's a right to buy it, you may not get your eviction with them. Part of the problem was there were a couple investors locally that took a big chunk of change out of people called an option agreement, and they got $10,000 or $15,000 out of a really bad property from these people. Put them in there, and 2 months later, when they were behind for 5 days, evicted them and kept the 10 grand. So the judges started hearing these stories, became very sensitive to it, and started asking a lot of questions. So if you're going to do an option, the one thing I like is truly make it 2 documents. Give me a lease agreement and do an option separate. Because there was a lot of them that came in with a lease option together, and when I put that in front of the judge as an exhibit, it's right underneath their nose. They're not missing that there's an option. If I have 2 separate documents and all I need is the lease, unless the tenant brings it up or knows to bring it up, it's not coming into the case.
Because I heard it kind of that kind of blurs the line.
Some of that gets,
they're getting equitable interest per month when it's not really the case.
Yeah, you have to make sure you're really clear about what you're doing. Yes, sir.
What are the laws on, are you able to rent rooms
So rooming houses, like in the city of York, there's specific zoning that allows rooming houses. The rooming houses, they exist all over the place. Actually, in the area, you can. The Airbnbs have gotten a little bit funky with some of the municipalities on zoning. We're seeing that happen, but you can do it. In the city, you have to get a zoning special exception in a bunch of the zoning districts to do it. They're limited about how many people can do it, but there are abilities to do it. It's the same eviction process, though, as if you rented the whole house or did a regular lease agreement. A rooming house is going to be the same thing.
So you have to get it zoned. You can't just buy a property and just try to rent out the rooms.
So you can check. There are some that allow it as permissive or permissible rights, but most of them it's been a special exception around here lately. But there's a lot of rooming houses in the area. So, yes, sir.
Is the rooming house the owner occupied or is it the boarding house?
Well, there's a zoning in the city of York that talks about it being owner occupied, renting out to up to 2 or 3 other people. I think it's 2 other people.
That's the boarding house.
Well, they call it rooming. I just looked at it today with a client. Rooming house was where it's owner living there, and then the boarding house was where it was non-owner occupied under the zoning.
You know, I know you are my expert, but I think you got them mixed up.
Okay. You'll have an email in the morning.
But regardless of that, Kurt, is there really a legitimate possibility that if you went in front of the zoning board for an exception to turn a single-family home into a rooming house, that there's actually a chance of getting that passed?
Yeah, they had one gentleman, I'm told, just presented it for 5 of them over in your neck of the woods.
Oh, I think the hearing is tomorrow.
Tomorrow.
We'll be attending, but he's going in with the idea that he has a student home license. He was already permitted to rent by the room to students, and now we're going to discriminate against the poor and indigent who can't rent the rooms even though the students were privileged to do so.
Yeah, I guess for his, from what I understand, and I don't represent him, but
I hope he's represented by someone.
I hope he is too. On that one, my understanding though is that he got approval from the planning commission.
Oh, did that go favorably?
For him. Now for the other person, it did not.
Cindy Mosbrook did not.
I can't say that now. Come on now.
Sorry, I didn't mean to blurt out, but
So,
I know there were 2 different
yeah.
parties. And I mentioned that to the party who was not successful, that she did not have the particular license that the other.
Right, there's
did,
different zoning
and
in
that
play.
That made the 2 cases different.
It
And
did.
Apparently the planning commission saw it the same way.
They did.
Interesting.
Yep.
Wow.
Is that my timer telling me to stop or? Yes, sir.
Just to piggyback off of that discussion right there, I know someone who may or may not be renting out rooms, but their business model may or may not be to rent out rooms to pedophiles. So what?
So is there a rule you can say no to it, you mean, or?
That may or may not be a business model. So he may or may not seek pedophiles to rent rooms out to.
So let me give a couple thoughts. One is so you know, Megan's Law Offenders are on a website. Where they live is put on that website. If someone wants to Google it, they can see where it lives. It's a problem for people when you're selling houses. It's a problem for neighborhoods. So you know, and here's what I can tell you. There's a case out there called Underwood versus Wind. Underwood versus Wind says that if I'm the landlord and I rent a house to somebody and they have a dangerous dog, I'm going to be responsible if I know there's a dangerous dog there. So if I have a house and I rented somebody that's been classified through the criminal system as a dangerous human being, what's my liability? That case is coming. So as part of your review is you can plug a name into Megan's Law and see if this person's a Megan's Law offender or no. But that's a real serious concern in my opinion for these units.
Right, so if he, so let's say he has 4 pedophiles staying in one house. So that just kind of multiplies liability.
It could, yeah.
So what would be, I mean, you say plug it into the system, but as far as seeking advice from attorneys, that's something that he probably should.
He probably should and look into it because if he's, one is if he's not operating legally with zoning, that could be a problem as the neighbors start figuring that out. Because it's school every year, in the beginning of school, a lot of school districts actually have lessons on this, talk about it. They send it out like, you know, hey, your kid's bus route's this. If you want to check the bus route and bus stops, feel free. We recommend it. And some people are plugging it in, and you'll see. So.
Of course, that's only for people who've been convicted.
Convicted, correct.
Right.
Yep.
So if he's seeking out
Yeah.
Is the landlord obligated to alert the new tenant that the neighbor next door has is a pedophile?
I don't think so.
Yeah, I don't think so.
Yeah.
That-
No, I mean,
we
it,
did 3 months ago, we were gonna buy a house, and we learned, as my wife looked it up, that next door, there was a pedophile.
well, when somebody's selling a property, you have a thing called seller's disclosures. And a seller disclosure requires that you have to detail anything that would impact the value of the home, argument, a defect. There's a lot of squirreliness out there about what covers that. I've had the case with the turkey vultures, where you've had turkey vultures that for 1 month a year come and roost in trees and cause damage to cars and such. We've had that. We've had the crazy neighbor cases and everything else. So, if you're selling and working with an agent, your best information is to tell the agent everything you know about it and get it out there so that it's accurate. But
I know how to get rid of them turkey buzzards.
yeah.
Bottle rockets.
Yes, sir.
Is it a hard process for that zoning, like to do the boarding room type of thing? Yes.
Some are difficult. The one in the city that I'm aware of is a special exception. So a special exception is that you're taking a position that I'm a permitted use so long as I meet these criteria. So if you can show the criteria, great. If you have to be what's called a variance, which is where you're actually asking them to change the way the ordinance or the zoning is read, you're going to ask them to change it. That's a very difficult process. And that's really a matter if they like the project or not, more of anything else. Zoning variances would be, like I had one in West York years ago. Subdivision goes in, they end up having this mistake by the engineer, and at the end of the day, at the entrance is a lot that was supposed to be half an acre, ended up being like an eighth of an acre triangle. And with the zoning setbacks, you had to build 20 feet in from every property line. You could pretty much put an outhouse in the middle, was about all you could get in this lot. So they went to the borough and they said, hey, we want a variance. We want you to take away that 20-foot setback and let us have 5-foot setbacks so that on this unfortunately very weird dimensional lot, we could actually build something. Otherwise, there's no use for it. If that type of scenario works, if it's self-created, if it's financial for you, you just can't make enough money, those aren't good enough reasons to get variances. Yes, sir.
I know what a variance, but a little off. I know in Maryland they started doing it more, but when it comes to title insurance, how come they really don't include, or most of the time it's excluded, boundaries?
In Maryland, Darren, you probably know better than me with Maryland, but right. Yeah, so typically, like when we just do title, we're not necessarily guaranteeing your line parameters or description. We're guaranteeing the history of the title, the claims that way, lien holders, ownership, right-of-ways, encumbrances, but your actual lines is a problem because they don't do surveys regularly here.
And of course, the buyer always has the option of paying for a survey.
Absolutely, yep.
We're putting it into a contract that they want a survey done before selling.
Yeah, but right. I mean, Maryland they're doing to do a survey all the time. And we see it all the time in our searches. We come up with survey errors all the time. Closure errors where the things don't meet and we have to try and figure out why. And
Yeah, I mean, I'm running into that with another property I own because there's a whole bunch of factors with that. It's alongside the old Paul Railroad, but then I got a right-of-way situation there too.
well, you have a different issue. So the old Mom Paul railroads, when they were abandoned, the argument is you can claim to the middle of it on each side. So you can actually claim to the middle of it. So people just recorded these wacky deeds without surveys and just said, oh, we're going to go this way 10 more feet and this way 12 and that way 10. And they end up with these squirrely deeds out there, but no one's actually done the surveys. Yeah. So abandoned roads, abandoned railways, unopened roads on subdivision plans.
But in my situation, the borough's clean.
Are they really?
The old railroad, yeah.
So the borough would,
Red line.
yeah, they would probably have it show up on their liquid fuel tax then if they've had it. And
But see, it's kind of weird though because like when I go up into the assessment page, like my keys is all that my attorney's working on now. Like they're showing that my property is closed, well they're dating it back where it runs along the trail the whole way.
well, that assessment map is not accurate though. Yeah, that's at the bottom of every one. It says that, and it's more of a guesstimate.
Further into that, the borough had bought the property 3 years ago, and they had tenants basically dropping like 2 acre property down and making a parking lot of it.
Ooh.
So now I got a trespass issue on top of that.
Good luck. Other questions right now? Yes, sir.
Okay, for the rooming house, I was under the impression that you go with a
All right, so great question. 4 or 5 years ago, we did a total class to the magistrates after the hurricane because they had all these issues with hotels and everything. If you're going to do innkeeper, you have requirements about a safe in the room. You have to have a pen log. You have to collect sales tax. You have to be approved by zoning for it. You're going to have about 8 or 10 things that click off that you'll have to find for that. So then what happens is the client looks at me and they said, oh, well, no, you know what? We're a bed and breakfast. And I looked at the client one time and said, that's great. What'd you make for breakfast this morning? They said, whoops, I guess I'm not a bed and breakfast. So we sort of went down, but you're going to look at your zoning. But if you start calling yourself an inn or innkeepers, there's also provision within the hotel and motels and such that once they're there 30 days or longer, you lose that protection. So you're not going to get that anyway. So a lot of these inns around here that have these long-term leases aren't falling under the Innkeepers Act. Innkeeper Act is great. What happened after that last big hurricane was all these people lost their homes. They moved in these hotels. They had nowhere to go, so they refused to leave. Well, some of them had lived there for 60 days, so when the hotels called the police to get them out, the police said, we can't do it. They've been long-term tenants. You have to evict them. So all these hotels end up with people sitting in their hotels having a look at eviction process. So we did the whole lesson on that issue. But yeah, be careful with the innkeeper because you have to have a bunch of criteria there. Yes, sir. So there's an issue about landlords when you're liable for like third-party conduct. And there are issues like if you said that I am Fort Knox Apartments and everybody's been screened and they're A1 personnel and you're safe here and you might have liability that way. I had a landlord one time that wanted to prohibit any weapons. And I said, well, that's great. You took away guns, knives, any weapons. So now when someone breaks in, they can't defend themselves. How are you protecting them? And I said, you better make sure you really have a great system in play there. But generally fights between tenants you're not going to be responsible for. Now what you may have to do is if you don't react after there's a problem and you just let them keep having it and the one guy's, let's say, is a constant bully instigator, you better be evicting him because the other guy has what's called peaceful enjoyment rights. And if you don't start getting peaceful enjoyment enforced and using the rules, then you could start being exposed, I think.
Wait, why next month?
So.
That's next time another meeting, but it's members only.
Sure.
Oh, I thought you meant for this tonight.
The house that we were going to sell, their financing company.
We'll get two this one.
But we're going to do a 6-month lease option.
I see what you're saying.
That would be credited towards their payment. If
You don't just want to get them copied out front?
You want to go out and get them?
What time is it?
Right, you can do that. But if you evict them in that time period, that's when you just got to be careful.
Right, but at the 6-month mark, I'm saying.
Yeah, if you've done compliance that way, you should be.
At the 6-month mark, though, how do you get them out if they don't exercise their option?
Then the option is ended. It's just an eviction.
Just a normal
Yep.
eviction.
Yep. Yes, sir.
If you're looking at a property, how can you tell if it's zoned for as a rooming house?
You'd have to contact the zoning officer. Yep.
Yep.
Yes, sir.
So if I'm in one judgment after I evicted a tenant, I'm trying to recover some loss and I know where the tenant has some assets, can you go over that process and what it costs you?
Sure. So when you guys get a money judgment out of magistrate, one of the things I'll do in some cases is at the end of 30 days, it becomes a final judgment. In most cases, if there's assets that we can recover or they have a good job and I can do wage attachment under that, we'll enter it at the county courthouse with pathonetary. I think it's around $38 or $40 these days, filing fee to get that judgment entered. That becomes a lien if they own other real estate in the county. It can be transferred from York County to any other county or state in the country if they have property elsewhere. It generates interest at 6% per annum, per year. So you could do that. You could then do a sheriff's sale garnishment of bank accounts. So when you guys think about it this way, just about every tenant in some ways seems like it's going to screw you and you're going to have a judgment, right? So if you take that approach when you're screening them, ask as many questions as you can up front. Where do you bank? When do you get paid? Do you own your car? Do you lease your car? What assets do they have? If we have those things in the end, you might have the opportunity to start finding assets to collect in the end from them too. We can garnish wages if they hit or above the poverty level. There are time periods when you can go after their wages and collect 10% of net wages. So the main process, though, is if you had a judgment, you could do it through the magistrate. You'd file with them to do a sheriff's sale of personal property. They'd go to where the people are. They'd inventory it. There'd be eventually a sale. You'd have the right as your creditor to bid your bid monies, your costs, and then you get the privilege of taking that stuff home as yours. What I like, what I like is if I know where they bank. I mean, they're paying you every month with a check. If you keep track of that and you know where they're banking, when these people get a judgment, you can take that judgment and force it through the sheriff and attach their bank account. So we do a thing called garnishment. You send the sheriff to M&T Bank. There's a form that they get served with, and they bring interrogatories, written questions to the bank, and they say to the bank, tell us what's in this account, and the bank freezes that account that day they're served. You get whatever in that after the bank gets their fees. So sometimes there's nothing there, but when you get it, sometimes there's something there. It's a neat option that you can exercise. Whatever you pay in the sheriff's sale cost, if it ends up being nothing there, that sheriff's sale cost gets added on to their judgment amount. So, all right, I got the wave from Harry, the hook that I'm almost done. I'll take one or two more questions, I guess, and I'll be staying afterwards. Yes, sir.
Going back to your month-to-month versus year leases, you have all your tenants on year leases, and then you have a bad tenant that you don't want to renew him on a year lease, but you want to put him on a month-to-month lease, but you also don't want to, you look at it like you're discriminating. Can you just say, hey, after 2 lease violations or something, like I'm going to put you on a month-to-month lease?
Yeah, I mean, you want to, whatever you do, you want to have a policy that you're following consistently. So where I have problems is like a client, when somebody walks in the door and says to me all of a sudden, you know what, I think I want to start collecting criminal information on my tenant applications. You know what, that wasn't the time to make that choice. You know, had you had your meeting, your business partners, yourself had a decision before they walk in the door, that's when you do it. But when the tenant walks in the door, you don't. Same here is I think, you know, you really want to have a layout plan in advance that if someone's not good, you're either evicting them or you're keeping them under these protocols. At the same point, depending on how bad they are, I wouldn't recommend keeping them around anyway. Here's what I look. Tenants are infectious if you have a bad tenant. They talk, they tell people stuff, they carry on, they cause you problems. You either want them or you don't want them. So there's no in between, in my opinion. Any other questions? Yes?
So, from the beginning, you said a lot of leases are for a year and then they go to month-to-month. So is that wording in the original lease continue on a month-to-month basis after that?
Correct.
Or that you don't have to have a tenant sign something maybe
Yep.
saying,
Good question. On the lease, there's an automatic renewal that says at the expiration of that term, it will automatically renew for the term. And some people do a year, some make it a monthly one, you know, but it's automatic renewing. Tenant has to give you advance notice saying they're moving out.
You
Yes.
said that you're leaning away from annual leases to month-to-month.
Yes.
What advantage would there be to keep the annual lease then?
So there's a perception with a lot of people that if you have longer lease terms, it will look better when you're selling it. It will look better to your banks. That's the one thing I've heard is people seem to think that. Yeah, I've been in the business almost 30 years. It doesn't really matter to me. It's the condition of the property, the neighborhood, you know, what's going on, payment history.
Another thing I wanted to mention is that what I started to do, kind of going back to your whole thing about damages, I actually have a sheet that has how much stuff costs to replace, whether it's blinds or windows or
Right.
cleaning or anything, and fill it out and I give it to them when they move in. And if I get the notice, hey, I'm moving out, I give it to them then. You know.
Yep. Yeah, it's very easy to document.
And then when they move, here is how much it's charging you to clean up or Facebook
Right.
or you know any of those other things.
Yeah, then the beauty is if you have it as like an addendum to your lease or in it, there's been this discussion, it's been out there, it's been adopted as part of your contract terms, and you have it, it's very easy.
Yeah, my particular pet peeve is batteries and smoke detector. So each smoke detector battery is $10.
Yeah.
And I know that's
You know, it's amazing. I went in for codes, we went in the day before for codes inspection, checked everyone, filled them all up, came back about 10 hours later, and everyone was gone. You know, maybe?
When they say about, I don't know if anybody knows it, but MrLandlord.com has printouts of everything.
Mhm.
And that's what I follow when I do evictions, whatever. I just basically copy
Yeah.
You got to be a little careful that you're following Pennsylvania law and not South Carolina or North Carolina. Okay.
Good.
I think he's from North Carolina.
Yes.
Virginia Beach. Or Virginia.
You're not given any leases, you're told there's no leases, but say maybe there actually are leases and they're in place for a year, whatever.
Right.
Are you liable to be stuck to those leases if you never receive copies?
You are.
If the tenants come up to you and say, I have a 5-year lease, you have to.
More than likely.
They would have to produce.
Yeah, they would have to produce. Yeah. But I mean, like there's some guys that have sold and said, hey, no, I don't have any lease with them, or I don't know where my lease is, no big deal. And some of them do have some long-term leases they've signed. You're stuck with what's been signed. Yeah.
A 5-year residential lease isn't legal, is it, Kurt?
You can have a 5-year. There's issues about when you record things and such, but.
But they have to produce it, though.
You're thinking of statute of frauds too. It has to be in writing, not verbal, for length of term. They would have to produce it. Yep.
So it's probably best just to ask for them to do like a 30-day lease before you even settle so that you know that you're handed.
Yep. Yeah, a lot of people will do actually go out, meet the tenants, talk to them, how's the place, what's going on, what's your lease terms, what are you paying, confirm things that way too. That is. Yep, yeah, so if you use it, I mean, we don't see it a whole lot in residential because I think it's just the nature of the effort, but an estoppel would be your tenant signing a form that says, I'm the tenant in unit 1A. I pay rent at $500 a month, I have a lease, I have no lease, it's 3-year term, month to month. My security deposit's X, I pay electric, there's no defaults. You'd have a basic thing they would sign off on it. Then if you went to bring an eviction, you'd say, I bought the property, here's the terms they told me existed, here we are.
Kurt will be hanging out after the meeting. If you have any other questions, you can ask him then.
Mr. Subtle here.
We're about
That's 2 for me.
Some guys just can't take a hand. Let's give Kurt a hand.
All right.
Thanks, Kurt.
Good job, man.
Thanks, sir.
Always a lot of questions on that one.
Everybody's looking for free legal advice.
Yeah. Yeah, if you want to get other questions answered on the cheap, I would recommend taking Kurt to lunch or dinner. All right. We're not done here.
What's that up there?
It'll go away.
Oh.
So, we got a couple things to go over yet. I'm going to hand the clicker over to Harry.
All right. We're going to talk about the unconscious mind and how powerful it is. Freud called the, what's that?
This is the part that is.
Freud called the other, where did you get this?
This is your email.
This is not me.
This is.
Oh, okay, I got it. Okay, you got to screw with me, don't you?
You're right.
You and Kurt, where's he at? You and Kurt. According to Freud, the unconscious minds continue to influence our behavior and experiences even though we're unaware of the underlying influences. Most people have no clue about the power of the unconscious mind and how much it controls our lives on a daily basis. Oh, you're really screwing with me.
You don't have to read all that stuff.
I don't even know what I'm doing here.
No, just go to the next one.
All of our basic instincts, urges, and how we interpret them are contained in the unconscious mind. Life, death, sexual instincts, survival, aggression, trauma, danger, and it holds many unpleasant and painful memories and repressed desires. Your unconscious mind is like an iceberg where you see 10%, but 90% of it is under the surface. Everything that you've learned from little on up, from a baby on up, is stored in your unconscious mind. It is the initiation of how you begin every thought process. So if you grew up and your parents were teaching you to avoid salespeople, they're pushy, they're bad, that's planted in your subconscious mind. And even as an adult, even though you may need help from that salesperson, you will want to avoid them. And that's your subconscious mind coming out. I'm going to kill you. It's your self-contempt. I'm going to kill you. That's not what I sent you. All right, who? I'm just going to wing this. Who cried when Old Yeller died? Come on, raise your freaking hands.
I didn't even see it.
All the millennials are going, who in the hell is Old Yeller?
I'm not a millennial, but I never watched it, so.
All right, sure, we all did. Come on. Why? It was a movie. It wasn't real. Why do we cry? Why do we cry? And I'm probably the biggest sap here. I cry when sports teams are win and they're the underdog, and my wife's going, are you crying? No, honey, I got dirt in my eyes. Why? Why do we cry? No, none of that. Because that's all in our conscious mind. Empathy, all that stuff's in our conscious mind. Our unconscious mind doesn't know the difference. It can't distinguish. It doesn't know the difference. And our subconscious mind is way more powerful than our conscious mind. It basically controls everything of how we feel, how we do everything. Why is this not working?
Point at this. Oh, the clicker probably, yeah. There you go.
The subconscious mind doesn't filter for truth, whether it's true or false. It doesn't know. It doesn't care. It just registers. It's like a computer. You know, all that information as you're growing up just goes into your mind, into your computer. And it doesn't care if it's true or false. It doesn't care about any of that. It just plugs it in, that in there. It accepts good and bad equally, such as a Freudian slip. Where do you think they...
Sorry.
When I sent it to you, it was spelled right.
It was.
Guess it was a little late. Guess where that came from. That it's supposed to.
My
be
buddy
spelled.
Fred.
Sigmund Freud. Sigmund Freud. Get it? Freudian slip. Okay. Have you ever said something and just blurted out real fast, and you went, "Oh my God, I can't believe I said that," or "Why did I say that?" Or why did I do that? Why did I react that way? Why did I do that? I'm so embarrassed. I can't believe I did that. That's your subconscious mind taking over. There's something in your past that created that situation. When you have a Freudian slip, that's exactly what that is. You ever heard people say, well, my mouth was operating faster than my brain. No, it wasn't. It was your subconscious mind acting before your conscious mind could react. Who has crazy dreams, right? And you wonder, what the hell was that dream about, right? Yeah, my dreams are I'm naked half the time. What the hell is that about? Who's had dreams where they're naked? Oh, just me. I should ask the question before I raise my hand. Right. Oh, come on, I know you're all lying. I'm in school, I'm trying to find my locker, and I'm not wearing any clothes. I'm not sure what that really means. But dreams come in a disguised form. Undercovering the true meaning is called the latent content. And Dreams can be a form of wish fulfillment, which could not be experienced in waking life.
So maybe
not good for me.
Maybe Harry wishes he could just walk around naked all the time, and that's where it's coming from.
Apparently, that's. All righty.
Oops, you clicked the wrong way.
You turned this off, right, Chad?
Next one.
Oh, sorry. So it's finding expression through dreams a lot of times. Now, the next time you have a crazy dream, you're going to be thinking about that, aren't you? You're going to wonder, what the hell did that mean? Why did I dream that? I mean, there's something in your subconscious mind that created that dream. Just thinking. Unconscious motivation. Hidden and unknown desires. Hidden and unknown desires. Things your conscious mind might not think about or want to think about, but it's there. This is a good example. When someone can't stay in a long-term relationship and they keep breaking it off, and they go, I don't know why I just can't stay in a long-term relationship. There is something in their subconscious mind forcing them to do that. Maybe they had a bad childhood, their parents broke up, then they got with other people, and then they broke up again, and it was a pattern, and they just planted that seed in their head that, it's not going to work, so let's just end it early. I don't know, but.
You're pointing at that.
So what we want to try to do is reverse some of that damage that's planted in our subconscious mind, because there's a lot of bad in our subconscious mind, probably more bad than good. So if I relate sales to the subconscious mind and we use it correctly, your mind will be free of all senses, competition, and anxiety in selling. And we're all salespeople. At some point in time, we're all salespeople. So how do we want to become better salespeople? Imagine your objective clearly, your goal. Keep that in front of you. Maybe your goal is to set a new sales record in your company, and when you achieve that, you'll have enough funds to buy that vacation house in Myrtle Beach. So you put that picture of the Myrtle Beach house in front of your desk. That's a clear objective, isn't it? And you're going to see that every day. And that will continue to nurture your subconscious mind.
Yeah, because a lot of time these sales goals, I want to hit such and such number, they're not really concrete. So having something like that pulls it together.
So you have to learn to repress negative thoughts. Negative thoughts are those thoughts that come in your head. I can't do that. I'm not smart enough. I don't have enough money. It's going to be too tough. I might fail. All those negative thoughts, you have to learn to repress them. You have to learn to reprogram your mind. And the best way to reprogram your mind, Dave said it earlier, is to hang around people that are positive. Hang around people that are successful. Eventually, you too will become successful. Partly is because you're reprogramming your mind without even realizing it. But I want you to try it while you're consciously realizing it. Because you reap what you sow, and you are what you think about all day long. If you think about negative thoughts all day long and how you can't do anything, next year you're going to be in here and you're going to be in the same position you are now. You have to think positive thoughts, constructive thoughts. Not, I can't do this, but how can I do this? It has to become a habit. And when it becomes a habit, your subconscious mind will follow that pattern, and it will start to change your life. When you start to see results, your subconscious mind will change, results will change. It's self-perpetuating. once you have a little success, your subconscious mind's going to like that, and it's going to appreciate that, and it's going to recognize that, and your subconscious mind will recognize it, and then you'll double down on it, and you'll have some more success. And exactly. So change or die. I'm going to leave you with that. Change or die. That last one was meant for Dave. Thanks for coming, everybody. We're going to be in the networking lounge a little later.
Oh yeah, we do have a slide for buy, sell, trade if anybody wants.
Oh, that's right. Buy, sell, trade. Anybody has anything they want to sell? Half of York.
I do have. Yeah. Nice. You don't see that every day.
Red Line is one of the few boroughs, or municipalities, I should say, that allow apartments to be separately metered for the tenants. Anybody else?
I do have a warehouse conversion project that's been approved by the city. If somebody's interested in that, I think it's 32 units, but come see me if that's something that you're interested
in. After hours networking in the networking lounge. David, I want to thank you all for coming. I hope you learned a lot from Kurt. And stick around.
Tune in next time to the Central Pennsylvania Real Estate Investors Meetup podcast, keeping you up to date with what is happening in the York, Lancaster, and Harrisburg, Pennsylvania real estate markets.